Zuber and Company, fire forensic experts and forensic engineers. Seeking answers from ashes. Seeking answers.
You know, we all pay for insurance for one simple reason, right? Peace of mind. It's this promise that if things go totally sideways, someone's got our back. But what happens when that promise gets tangled up in the fine print? Well, that's what we're diving into. This is the wild story of an exploded boiler, a flat-out denied claim, and a legal showdown that went all the way to the Supreme Court. And it all came down to a few little words hiding in plain sight. It seems like it should be a simple question, doesn't it? You're insured, so you're covered. But the answer, as this story shows, can be a whole lot more complicated. This is all about the gap between what we think our insurance covers and what that contract actually says. Okay, so let's set the scene. You've got two main players here. On one side, we have a sugar factory in India, the Kopergaon Sahakari Sakar Karkhana, and on the other, the National Insurance Company. The factory does exactly what you'd expect a responsible business to do. They get an insurance policy for their most important gear, and that includes a huge boiler. Pretty standard stuff. And listen, this was not a small policy. We're talking about coverage for 1.6 crore rupees. That is a significant chunk of change. So you can imagine, when disaster hit, the factory was absolutely ready to fight for what they were owed. Now, check out this timeline, because things move fast. The policy gets issued in February. Just about 3 months later, in May, boom, the boiler explodes. And then, barely a month after that, the insurance company comes back with the bad news: claim denied. Just like that. So the insurance company didn't just say no and walk away. Oh no, they had their reasons. They pointed to their own investigation, a surveyor's report, and one very, very specific clause in the policy. Their whole argument was that this wasn't some sudden freak accident. They claimed it was something else entirely. And here it is, right from the horse's mouth. This is from their official denial letter. The insurer's whole argument was that the boiler failed because of long-term corrosion and decay. So in their view, this was just old equipment finally giving up the ghost. A classic case of wear and tear, not an accident that would trigger a big payout. And they had a report that seemed to back this all up. The surveyor painted this picture of really aging equipment. Heavy corrosion, tubes that were loose and bulging. They even noted that a lot of these parts had been put in way back in 1986. So the conclusion felt like a slam dunk. This was slow deterioration and therefore not their problem. The whole case for the insurer rested on this one thing: exclusion clause 5. Pretty much every insurance policy you'll ever see has these. They're the parts that spell out what is not covered. And this one clearly said they wouldn't pay for damage from stuff like corrosion or just general wear and tear. So, case closed, right? Well, not so fast. The sugar factory, they weren't having any of it. They insisted an explosion did happen, and they were owed that money. So, they took the insurance company to court. And this kicked off a legal roller coaster that gave them completely different answers as it went from one court to the next. Okay, get a load of this, because this is where it gets wild. The first court, the state commission, sided with the factory. They basically said, hey, insurer, you should have checked out the boiler before you took their money. Plus, it had a valid fitness certificate, pay up. But then, on appeal, the National Commission, the NCDRC, completely flipped the script. They sided with the insurance company, saying that surveyor's report and exclusion clause 5 were the only things that mattered. Complaint dismissed. So you've got one case, two courts, and two totally opposite results. This was setting the stage for a final showdown. With everything hanging in the balance, the case lands in front of the Supreme Court. The entire multi-year, multi-million rupee fight now came down to how you read one single clause in an insurance contract. The court had to figure out, what did exclusion clause 5 times really mean? So here's that key part of the clause one more time. It lists all the things that are not covered: wearing away, corrosion, fractures, bulging tubes. It seems pretty comprehensive, right? It looks like the insurance company has this in the bag. But take a really close look. Can you spot the tiny detail that everyone else seemed to be missing? And there it is, right there, in parentheses, a massive exception hiding in plain sight. The clause says it excludes all that wear and tear unless that wear and tear results in an explosion. And what was the one thing the factory had been saying from day one? An explosion happened. This little word was the master key that unlocked the entire case. So here's the bottom line. The very clause the insurance company was using as a shield was actually the factory's sword. The Supreme Court pointed out that if an explosion happened, which the factory always said did and the insurer never really proved otherwise, then the whole exclusion for wear and tear just goes away. It doesn't apply. And the court didn't just stop there. They also looked at the bigger picture here, bringing up this really important principle called utmost good faith. They said insurance has to be a two-way street. An insurer can't just take your premium payments without doing their own homework. I mean, the factory had a valid fitness certificate. The court put the burden of proof squarely on the insurer to show that the factory was hiding something, and they just couldn't do it. So, after this long, winding legal journey, what was the final outcome? And probably more important for us, what can we all learn from this whole saga of an exploded boiler? Well, the Supreme Court ruled decisively in favor of the factory. It completely overturned the National Commission's order and sent the case back to them with one very clear instruction. This claim is valid. The only thing left to do was to crunch the numbers and figure out the final compensation. This whole case leaves us with three really powerful lessons. First, you have to read the exceptions. The fine print that can take things away can also give back. And sometimes the most important words are tucked away in parentheses. Second, insurers have to do their homework. They can't just cash your checks and then cry foul later. And third, that good faith idea is a real shield that protects policyholders and makes sure the whole process is fair. And that kind of brings us to the final thought here. This entire drama, from a factory in India all the way to the highest court in the land, it all came down to a few words in a contract. It really makes you wonder, doesn't it, what little exceptions are hiding in the fine print of your own policies?